Hello, everybody. Welcome back to the Texas Jurisprudence exam prep course, and this is the second part of our video course in order to help prepare you for this exam. So last time we left off with Section 5, and we're now going to pick up with Sections 6 through 10 here. Section 6 is discussing medical records and disclosure when we start to look at consent and things of that nature. So let's talk about record-keeping requirements. As far as physicians are concerned, if the patient is an adult, they have to keep all records for 7 years from the last time that they saw the patient or had some sort of communication with the patient. If the individual is a minor, it goes between two different potential timelines. So the physician, in the case of a minor, is going to need to keep the records until the patient is either 21 or they need to keep it for 7 years. So that can lead to differing scenarios. And you can see here we have a set of scenarios. If there was a 17-year-old that a physician saw, then the records need to be kept until the then minor is now 24 years old, or if the last time the physician saw the minor was when they were 10 years old, they would need to keep them until 21. So note that it's whichever situation comes later. You need to hold on to them as long as possible. So if the 7 years is going to bring it to a later age or a later date than the 21 years, then that is what needs to be observed. And keep in mind that if you are involved in any type of lawsuit, so civil or criminal, you need to hold on to those records for the entire proceeding until it has been resolved in court. You cannot, even if it meets one of these dates that we've mentioned above here, you cannot throw out or get rid of any of these records if you are in an ongoing legal situation involving, obviously, the patient in the lawsuit. So for hospitals, it's a little bit different than physicians, but it's sort of the same setup as far as the minors are treated different than the adults. So for hospitals, they must keep records for 10 years for any adult patient that comes through. And then if it's a minor, they need to keep them either for 10 years or the patient's 20th birthday. Again, whichever one is longer. So you could think of another type of situation like we saw in the previous slide, but whichever of those is longer is the one that they must keep it till. Now, what happens when you have patients that are requesting medical records? If you receive a request for a medical record, you have 15 days as of the receipt of the request, meaning once that request has actually been handed to you, you get it in the mail, whatever it might be, the receipt of that request. Even if balances are overdue, you have to release those records, legally speaking. You can deal with the overdue balances in other ways, but you have to always release the records. Now, there is an exception to this. You can deny a patient their records, but you have to have reasonable cause if this is going to happen. So what is reasonable cause? You're going to have some reason that releasing these records could cause physical, mental health, emotional health to the patient. And if this is the case and you think this is what's happening, as a physician, you have to still provide a rejection notice. And this still has to happen within 15 days, just like if you were to provide the actual medical records upon receipt. Now, this is important because if you come across a question that asks that a patient always has access to their medical records, the answer to this is technically that they may not. Most of the time they're going to. However, there may be a case where the physician deems that it's in the best interest of the patient with reasonable cause that they cannot have access to their records. And in that case, they are allowed to be withheld. Now, when you get ready to provide records, as a physician, you are entitled to money. So you can request what's called a reasonable fee. This is a reasonable cost for whatever is involved in these records. So let's say that you're just printing up records or making some photocopies. It would probably not be reasonable to charge a $50 fee for some paper and postage. However, let's say that they are requesting copies of X-ray films that are substantially more expensive material-wise than the printer paper or the copying machine. And in that case, you can ask for a reasonable fee to help cover the costs of providing those records, whether it be in paper or electronic format. Now, in the case of a lawsuit, you have to release medical records within 45 days. So just keep that in mind because we have had discussions here about malpractice and lawsuits and things like that. So in the case of a lawsuit, you have 45 days to release medical records. What happens if there's an error in a medical record, whether you find it and you change it or you're going along and you realize as you're putting it in there that you've made an error? Errors should be struck out with a single line through the error. And then once you have struck out that line, it's going to need an initial. So your initials as the physician, a date, and then you need a clear identification of what the correction is. So you don't just cross it out and put the date with your initials, but you need to then, underneath it, to the side, wherever it might be, make it very clear what the correction is supposed to be once you've crossed that out. So going along with medical requests, because that's what we were just talking about when people were asking for medical records, what happens as far as medical record requests without consent? So there are some situations where you may find that medical records are being asked for without the consent of the patient. And you can give these over, but it's in very specific cases. So one of the first examples is TPO, which is treatment, payment, or operation healthcare activities. If it's for any of those purposes, then you may go ahead and disclose it. and then as required by law. So if you have law enforcement requests coming through, if a court is mandating it or there's a subpoena for certain files, if there's any type of abuse situation where it may be mandated by a social worker or, again, a court system, in that case, if you're required by law, you have to give them up, even without the certainly without the patient's consent. You don't have to have the patient's consent in order to give those over in a case like that. Now, communicable diseases and their time frames as far as reporting them. So this can change a little bit depending on the specific disease that we're looking at. So for most of them, when you're looking at most of the communicable diseases like gonorrhea, salmonella, syphilis, you have to report them within 7 days of occurring. So just a little memory aid to help you out here. You can see what's written on the slide. We have STDs, salmonella in 7 days. So think about, you have gonorrhea, syphilis, and then you have salmonella, the S in STDs, the S in salmonella for 7 days. So if that helps you, that's great. And then what happens in the case of TB, pertussis, and HIV, those all have to be within a single working day. Now, there are some that have to be reported immediately, and that is if you come across any type of bioterrorism. So we're talking about things like smallpox or anthrax. If there are any reports of those or you come across any examples, or SARS, if you see an outbreak of anything like that, it must be reported immediately. Now, when you get ready to look at doing diagnosis of a communicable disease, sometimes there are confusions as to what your duty is as a physician. So let's say that you treat a patient. If you have a patient that has gonorrhea, what are your duties as a physician? Who do you have to tell? What needs to be disclosed? So number one, you need to inform the health authorities, and that would be the State Department of Health. As far as they're keeping records, because we need to know how many people have the communicable disease, even if you're going to go in and get treatment for it. You inform the health authorities, and then it's also your duty to inform and educate the patient on how to prevent the spread of the disease. So whether it's something that you can help as far as curing or at least managing it, you then have a responsibility to at least inform and educate that patient on how to prevent the continued spread of that disease so that we don't have a further outbreak. Now, there is no existing duty for the physician to inform or educate the spouse or other people. So that could include children, that can include girlfriends, fiancés, a spouse. If this individual has come to you as the physician, you do not have a duty to report this to anybody else. And that can include people that they're sexually active with. All right, so reportable conditions. In many cases, there's going to be a reportable condition, and you need to know what these are. So in Texas, we just discussed some of them are communicable diseases, right? You have the newborn child with an anomaly or a birth defect, an unclear death of a child that's under the age of 6 that would need further investigation, lead poisoning, a drowning incident or near drowning incidents, brain or spinal cord injuries, and gunshot wounds. Those are all reportable conditions, right? Now look at the note down here. Note that it is not required to report overdoses for non-controlled substances, such as a drug like aspirin, okay? However, drug overdoses with penalty group 1 substances, these are controlled substances, these are higher level narcotics, they must be reported. So note that these are going to be reportable to the Department of Health, not the Texas Medical Board. So this is not a board issue. This gets reported to the Department of Health when we're talking about these types of drug overdoses. And again, you're looking at the heavier stuff with that. So child abuse. We talked about child abuse earlier briefly when we were going over the whole misdemeanor and crimes that would be reported to the board, whether it was a felony or a misdemeanor. So let's get a little further into child abuse here. When you suspect any type of child abuse, whether you have direct proof of it or you have a good suspicion of it, how long do you have? You have 48 hours to report child abuse. So if there is a good suspicion and or you have proof of this, you have 48 hours as a physician to report this abuse. If it's a non-professional, the child abuse must be reported immediately. So in other words, if you are not the physician, if you are a non-medical professional, it needs to be reported immediately. Remember that the child abuse doesn't always have to be confirmed. It can just be a suspicion of it. So this is important. You need to realize that just a suspicion is allowable. You will not be held responsible. So if let's say that you have a suspicion that you see this minor, it looks like they've been abused, but they're not really talking about it, and you figure you're going to go and you're going to go ahead and report it. So in that case, the physician, if you go and report it as a physician, you will be immune from any liability if it turns out to be false. But it has to be made in good faith. So you have to have reasoning behind it. You can't just do this sort of as a malicious act because you used to date the child's mother or something like that, and then you are angry about that the two of you broke up. Something, you have to have a good reason for it. It has to be done in good faith. Otherwise, you could be held responsible. Now, what if you fail to report it? What if you don't report it and there was a suspicion or it was known? So failure to report it is a Class B misdemeanor, and we did talk about this earlier in our list. That's back in not section 1, but the first video that we did. Okay, so fraudulent reporting of child abuse is a third-degree felony, and that's what we were just talking about there. So if you are making fraudulent reports about it, meaning you know it's not occurring, but you're going to do it anyway to get back at somebody, or because perhaps you stand to get monetary gain, whatever it might be, that's going to be a felony. Okay, The name of the reporting physician is always going to be confidential information unless the physician consents to release this info. That is a very common exam question. So keep in mind that if you report any type of child abuse, your name as the physician will be held confidential unless you are going to consent to release that information. Now, what about elderly abuse? Because this was also on that list when we were looking at the misdemeanors and we were looking at the felonies. So in terms of elder abuse with nursing homes, an oral report needs to be done immediately, and then you can do the written report within 5 days. So if you see anything going on with elderly abuse in nursing homes, you need to immediately get the oral report in. And then once you have the oral report in, you have up to 5 days to give the written report. Okay. Now, the Department of Protective and Regulatory Services will not start the investigation any later than 24 hours of a report of suspected abuse. So as soon as this oral report goes in, as soon as you start filing this, within a day, they are going to be there investigating this case of abuse. Okay. Now, report of a nursing home death needs to occur within 24 hours after the resident is transferred to the hospital. So if there is any type of a nursing home death and they go to the hospital or whatever might happen after that, there's 24 hours in order to report that. And just as a reminder, back to that first list that we took a look at when we were discussing misdemeanors and felonies, sexual abuse of nursing home patients is considered a felony. Now, domestic violence, because we've talked about child abuse, we've talked about the nursing home abuse, that's the minors and the elderly, right? So what about just your regular domestic violence? In the case of domestic violence, and again, we're excluding the elderly or children here, the physician is going to need to document the findings. They must offer to call local authorities, and they have to provide resources for shelters, okay? That doesn't mean you have to call them. You have to make the offer to call. So if somebody comes to you, let's say that there's spousal abuse going on or something like that, you have to make the documentation. You have to offer this individual whether they would like you to call the local authorities, and then you should have some sort of resources for that patient regarding shelters and where they can go get help. Now, what's different here, unlike the child and the elder abuse, no criminal act has occurred, such as a misdemeanor, in a failure to report this. So if this person is a competent adult, and when we say competent, it means certainly they're not a minor or elderly, but they're also of sound mind, they're not mentally retarded, they can think and speak for themselves, even though they might be emotionally traumatized. So if you do not end up making a report of this case, it is not going to be considered a misdemeanor because of the failure to report it. All right, so the Tarasoff duty. So this is, in other words, a lot of people haven't necessarily heard this term, but this is the duty to warn a third person who's being threatened. So let's say that your patient comes in and starts making threats about how they're going to go hurt so-and-so because they're so angry. So the Tarasoff duty has not been adopted in Texas. And in the event that you're going to have a patient that is threatening to harm other individuals, your responsibility is not to go and tell those individuals, it's to go and call law enforcement. So you need to call the local authorities if you have a patient that is claiming that they're going to go out and they're going to start hurting other people, or, you know, they have the intention of anything like that. Okay, Section 8, Advanced Directives and Consent. So advanced directives, which are composed of living wills out of hospital DNRs, or medical power of attorney, do not expire and can only be revoked at any time without regarding the patient's competency or mental status. They can also be revoked orally. So remember that pain control and other comfort procedures are not life-sustaining measures. These are exam questions here, okay? So the living wills, the out of hospital do not resuscitate, and the medical power of attorney do not expire, all right? And on top of that, if we're talking about something related to pain control that is not life-sustaining, okay, then that also applies here. So you need to keep in mind that mechanical, ventilation, CPR, and dialysis are life-sustaining procedures. So in a case like that, you're not just managing pain, you're actually keeping somebody alive and or trying to resuscitate them at a point like that. Right? An advanced directive issued or created in another state is also going to be considered valid in Texas. Right? Now, insurance companies are prohibited from treating any person who's executed advanced directive differently. They may not restrict or inhibit the sale of insurance nor modify the terms of an existing insurance policy. So once that insurance policy is set in place, they cannot go in and modify the terms. Now, according to Texas law, a person may not withdraw or withhold life-sustaining treatment for a pregnant patient, and that the advanced directive has no effect. All right, now what about surrogate consent? So if an adult patient is unable to provide consent for a procedure due to being incapacitated or mentally ill. So let's say you have maybe a patient that is in a coma and you realize that you need to go in and do some sort of life-saving operation, but the patient is incapacitated, so they cannot give consent. So what's going to happen in this case? Well, first you would defer to a legal document. So do they have a will regarding, you know, their wishes in a case like that, or life support or anything like that? Now, if nobody has the medical power of attorney and they don't have any sort of document in order, then the way that the consent is going to go if the patient is incapacitated or cannot make the choices for themselves is the spouse. So if the patient has a spouse, they get the first say. If the spouse either rejects or there is no spouse, then you look towards adult children. So does this patient have any children that are going to be over the age of 18 that could make this choice for the patient? If there are no adult children, or again, if we're going down the line, they're declining or deferring, then the next one you would go to would be parents, so the parents of this patient. And then finally, if those parents cannot make a choice, we have siblings and other family members, whether they be aunts, uncles, cousins. That is the general flow, and we're going to see this again in a few minutes, but that is the general flow of authority when the patient cannot make consent for themselves for whatever the reason might be. Now, keep in mind, because we do have exceptions here, anytime you want to do electroconvulsive therapy or psychosurgery, something like a lobotomy, these are two examples of procedures that you cannot get consent unless the patient explicitly gives consent. So if you have a patient that's unconscious, or let's say that they're mentally ill, their spouse cannot turn around and say, well, we're going to try a lobotomy, that's what I'm approving. This is something that only the patient can consent to, no matter what. So when it comes to minors and dealing with consent for minors, most people know that the parents would be the people that you would typically go to. So parental consent is not required under some circumstances. So most of the time you're going to need parental consent, but here are the times where it's not necessarily required. So if you have active duty military, if the child is going to be greater than 16 years of age and is separated from the parents and managing their own financial affairs, so they're an emancipated minor, and we're speaking about this legally. In other words, they have separated from their parents, they are taking care of managing their own affairs on their own. When you're treating any type of contagious disease or infectious disease, if you're dealing with drug addictions, or if you're dealing with any type of treatment related to pregnancy, you do not need parental consent. However, there is an exception for abortion, so you need to keep that in mind, that parental consent is required for abortions in Texas, but again, there's going to be special cases for the abortion, so it's like special cases within special cases here. And then sexual abuse and suicide prevention. So in any of those cases, you are allowed to treat these minors without the consent of the parent if they meet any of those. Now, what about the abortion? Abortion is somewhat of a special case. So while it's related to pregnancy, the parental consent is required. Okay, but the exception to the rule is whenever there might be emergency situations or a court order. So let's say that for some reason there really needs to be an abortion because the life of the underage mother is at risk. And when I say underage, I'm talking about she's a minor still. So if there's something where the abortion needs to happen within a matter of hours and they can't get a hold of the parents because there's some sort of health issue that's going to, affect the mother, then that could be an emergency situation case. Or again, if a court order allows for it. All right, so organ donation. When we get to Texas law with organ donation, if the individual is a minor, so if they're younger than 18 years of age, then they can not effectively be an organ donor. However, there can be what's called the gift. You can gift an organ donation, and that's usually shown on the driver's license or the identification card of the minor. So the gift is not effective for individuals younger than 18 without the approval or consent of the person's parents. So what this is all basically saying is, if you are under the age of 18, you are not permitted to be an organ donor unless the parents give the green light on that. Okay. Now, in cases where the parents are not able to be reached, then we do this whole type of thing again. So then it's adult siblings, then we have grandparents, legal guardians, or school principal. If they had written authorization provided by the parents, then you could have these people consenting to be an organ donor. The same thing applies for the immunization of children. So when you're dealing with giving children vaccines, that can obviously be a touchy issue for some parents, and parental consent needs to be involved in that case. Now, when you deal with this, if the parents are not available, you go down that chain of command like we were just discussing. And if the parents are not available, again, adult siblings, grandparents, those with written authorization. So what about adults? For adults, the order of decision-making for consent for organ donation is spouse, adult child, parents, and then siblings. That's exactly what we saw earlier, and I said, oh, this will come back up a few minutes later. So remember that consent for organ donation has to be in writing. We keep talking about this written permission from the parents when we're dealing with this sort of stuff. Now, this is also written permission from an adult. So if, let's say that I was not listed as an organ donor, and my spouse wanted to vouch that that was going to be my wish, my spouse would need in writing some sort of consent that I'm looking for organ donation. Okay? So take note of this here because this is important. It is a major conflict of interest for a physician who is taking care of a patient to then subsequently be involved in procurement of that patient's organs for the purpose of transplantation. A medical professional who pronounces death of a patient cannot be involved in the subsequent organ harvesting. There has to be a break in that relationship as far as the person who's actually harvesting these organs versus the actual physician that's treating them and pronounces the death of the patient. All right, so I told you we were going to come back to HIV. I started giving an example, and I said let's hold off on that because HIV's got all sorts of special rules, and it gets its own section here. So let's start talking about consent for HIV. If a general consent form has been signed and it covers all diagnostic testing, that would be sufficient, and a special form for HIV testing is not required. So if the patient comes and signs a general diagnostic testing form saying, hey, you can test me for whatever, then that is sufficient. You do not have to go to them and say, I know you just told me I could test you for whatever, but can I also test you for HIV? You don't need that separate special form for that if they signed a general diagnostic testing. Now, if there is no general consent that's been signed, you have to provide the specific HIV test consent form, and that needs to be signed by the patient. Okay? Otherwise, if you test for HIV without consent of a patient, it is going to be classified as a misdemeanor. So you're not permitted to turn around and test for HIV without consent. Now, of course, there are going to be exceptions, just like everything else we've looked at. So when there are positive HIV tests, they cannot be disclosed without the patient consent, except, there's a couple of exceptions here, partner notification programs, okay, the patient's legal spouse. So the physician will not be responsible if he does not notify the spouse. However, you can legally go and tell the patient's legal spouse, the person that they are married to, and say, your husband and or wife came in, they tested positive for HIV, and you don't need that patient's consent. Notifying the Department of Health and the other public agencies, so the record keeping, that you don't need the consent of the patient. We kind of discussed that already. And keep in mind here that positive test results must be disclosed in person. This cannot be done over the phone. So you cannot call somebody up and say, hey, you've got HIV, you're positive. Okay, the positive test results must be disclosed in person. All right, section 9. We're now going to talk about mental illness. This is a relatively short section, but there is important information in here. So, as far as psychiatric admissions, because when we start talking about mentally ill, we're going to talk quite often about people that may be involuntarily subjected to one of these institutions or places if loved ones and or other individuals feel that they might be a threat to those around them or themselves. So, an involuntary psychiatric admission is only going to be justified when you meet two criteria here. Right? Number one, the patient is mentally ill, and number two, there's an immediate threat to self or to others. So that's sort of what we just discussed a minute ago. Both of these conditions need to be met, and this is a common exam question. All right, so it's not okay that they're just mentally ill. It's not okay that they're just making threats to people, because those each have their own separate, if somebody's just making threats, you call the local authorities. You don't put them in a psychiatric ward. Okay, if somebody's mentally ill, but they're not showing any type of threat, we're talking about involuntary here, then you cannot check them in against their will. Like, let's just say that they're in the corner and maybe they're, talking to themselves. If they're not showing an immediate threat to anybody, all right, that doesn't mean that you get to go and you get to put them in against their will. So if you meet both those conditions, they're mentally ill and they pose a threat to either themselves or to others, then both conditions have been met, and they are subject to an involuntary psychiatric admission. Okay, now once they're in there, the patient needs to be examined within 12 hours of an emergency detention. So you get them in the door, within 12 hours they're going to need to be assessed. There is no consent that's needed for involuntary admission. That's kind of obvious, but you don't need the patient to say, yes, I consent to going in, because at that point we're talking about voluntary admission. All right, now dementia, epilepsy, alcoholism, and mental retardation are excluded from the definition of mental illness. However, bipolar disease is considered as a mental illness. Okay? So sometimes there's these borderline things that people like to say, oh, this is a mental illness, this is a sickness. You cannot, for instance, if you have somebody who's an alcoholic and they're constantly getting drunk and then they're getting violent, you can't say, well, because they're an immediate threat, they're violent when they're drinking. You can't call their alcoholism mental illness and get an involuntary psychiatric admission. It's not going to work that way. All right, so the guidelines for consent and voluntary psychiatric admission. So we just discussed the criteria for meeting the involuntary. What if the patient is going to consent and do a voluntary admission? Okay, the psychiatric admission must be agreed to by, here's the list, the patient if the patient is 16 years or older. So if it's a 16-year-old or older, the patient. The patient if the patient is under 16 and is or has been married. The patient's parents if the patient is under the age of 16 and has never been married. Note that the patient under voluntary admission still retains his or her personal rights. So if they're going in on a voluntary basis, they have all of their personal rights. What about restraints? So we're talking about physical restraints where we're strapping people down to beds, we're putting cuffs on them, something like that. So restraints should only be used if the patient poses an immediate danger to self or others. Now, when you place restraints on the patient, okay, you have 1 hour to evaluate that patient once they've been restrained. And within 4 hours, the order for the restraints will expire. You cannot have standing orders or constant orders that the patient is always to be in restraints. Whatever you might see on TV or movies with things like Hannibal Lecter, you cannot constantly restrain your patient, all right? If there is a need for it, if they have a particular threat or they've shown a threat, you can use the restraints. You have 1 hour to evaluate them. You have to do that within an hour. And after 4 hours, the order for the restraints will expire. All right, the last section, section 10, we're going to talk about drugs in this section. So let's first talk about the scheduling of drugs by the DEA, which is where we're going to kind of break these down into the different classes. Now, the easiest way to look at the breakdown of these drugs is I find it's good to look at it as Schedule 1 is by itself, Schedule 2 is by itself, and then Schedule 3 through 5, they have their own different uses, but they are typically going to be grouped together as far as prescriptions are concerned, legality, all of that kind of stuff. Right? So Schedule 1 drugs for the DEA are going to be illegal drugs. So these are things like marijuana. Now, granted, marijuana is starting to gain acceptance, at least if we're talking about this in the U.S., because this is a Texas-based prep course. All right, but there's certainly other ones when we're talking about heroin, LSD, cocaine. Those are all Schedule 1 drugs. And we'll talk about this in a minute, but as a physician, you have no business prescribing any of that sort of stuff, right? So you're not going to turn around for a patient and be like, let me write you a script for heroin so that you can go and take care of your pain. Now, Schedule 2 drugs, okay, are going to be the drugs that are highly addictive but are going to be considered of legal use for prescriptions. So you've got your oxycodone, your morphine, okay? This would also fall into the class of Adderall, Ritalin. There have been big problems with this type of stuff on college campuses when people start taking some of these for focusing. Note here it says cocaine. Cocaine is a topical anesthetic or in nasal or eye surgery. So there's very restricted uses. You can't just turn around and start prescribing, lines of cocaine for somebody. You have to deal with the topical anesthetic in very specific situations here. Now, Schedule 3, okay, are going to be the anabolic steroids and the codeine-containing drugs. Schedule 4 are sleeping pills, such as Ambien. And then Schedule 5 are the drugs with limited amounts of codeine for the purposes of things like anti-diarrhea, anti-cough. So when you've got these Schedule 3 through Schedule 5 drugs, it's not to say that they can't be addicting. They can be addicting, and they would still need prescriptions. People can get very addicted to Ambien and need it for sleeping. However, it's going to be less prone to addiction problems in comparison to the Schedule 2 drugs. Things like oxycodone and morphine are highly addictive to the point that you'll often get patients that once they run out of it, they will start looking for other sources of it if you're not going to continue prescribing it. Okay. All right, so let's get a little further into this. I kind of mentioned it as we went along, but we'll recap some of this here. So I think it goes without saying, there is not going to be a physician that is permitted to prescribe a Schedule 1 drug. Schedule 1 drugs are substances which have high potential for abuse, almost guaranteed potential for abuse. And the drugs in that Class 1 or that Schedule 1 can lead to very severe psychological and physical dependence. So Schedule 1 drugs do not have any current accepted medical use in the United States. Now, a Schedule 2 drug is going to be a substance that, as we stated, has high potential for abuse, and it could lead to some psychological and physical dependence. However, these drugs currently have been accepted for medical use in the U.S., but they're going to have very severe restrictions, right? So if you're going to prescribe Oxy for somebody, it's not going to be that you get to give them, here's your Oxy and you've got 12 refills for the next, 3 months or something like that. So let's talk a little bit about Schedule 2 prescriptions, because Schedule 1's easy. You're not supposed to be prescribing it. You're not even supposed to have it. Now, for Schedule 2 prescriptions, it cannot be written by mid-levels except in a hospital setting, right, where the patient there is hospitalized and inpatient for more than 24 hours. So we've already discussed mid-levels in a previous section. If you're dealing with mid-levels, the mid-levels cannot be dealing with writing prescriptions for drugs at this level. That needs to be the attending physician and not any of the mid-levels, okay? So let me just finish reading this here. So you've got the setting where the patient is hospitalized or has inpatient care for more than 24 hours, and an ER if the ER is attached to a hospital and is not a freestanding ER, and hospice as well, okay? So that's a very typical exam question, all right? The mid-levels cannot prescribe any of the Schedule 2 drugs except in a hospital where the inpatient has been there for more than 24 hours, in an ER, and that ER has to be attached to a hospital. It cannot be a freestanding emergency room, and hospice. Those are the 3 exceptions. All right, no refills can be provided for any Schedule 2. And you must use Texas-controlled prescription form when you're doing this. So sometimes this is known as triplicate or a certified electronic controlled substance prescription vendor. So you have to go through all the proper channels when you are prescribing this. Now, what happens if you do need to write this for more than one round? Let's say the patient's going to need to be on these painkillers for several weeks due to some severe surgery or something like that you did. All right, so you may write multiple prescriptions to cover a maximum of a 90-day period. So, for instance, you can write a prescription that is to be filled on December 1st, 2016, okay? And that's the earliest fill date. And then you can write a second prescription, and the earliest fill date is for January 1st, 2017. And then you can write a third prescription, and the earliest fill date is for February 1st, 2017, right? So that spans a 90-day period, but you're breaking it down, and you're not turning around and saying, I'm going to prescribe you this, oxycodone, and you get 3 refills. Because at that point, as soon as the first one is filled, they've got access to those 3 refills. So this is a way of providing what's needed, but it's staggered out at a certain amount of time, right? So if the patient goes and takes all of the oxycodone in the first 3 days, they're going to be out 27 days before that new prescription can be filled at the earliest. So it provides a little more control. All right, now Schedule 3 through Schedule 5 prescriptions. So these are the ones that are a little bit lower on that list, and you're going to see that it starts to ease up some more as far as the rules concerning these. So now mid-levels may write Schedule 3 through 5 for any outpatients. These are things that it does not have to be the lead or the attending physician. You can have the mid-levels that are dealing with that. A limit for mid-levels is 90 days per prescription when you are doing this, and that includes refills, okay, based on however often there's, the medication is supposed to be taken. So they do have caps on how many refills they can provide, but they can start providing this medication. So a mid-level can write, for instance, a 90-day supply for a Schedule 3 medication, or a 30-day supply for a Schedule 3 medication with 2 refills, or a 15-day supply with 5 refills, etc. The point here is that the limit is 90 days, and that includes all of the refills. They cannot go past that. So in all cases, the prescription for a Schedule 3 through 5 is going to be written by a mid-level. It is only valid for 90 days. Now, Schedule 3 through 5 prescriptions that are written by a physician are good for 6 months or 5 refills. Okay, so mid-levels, 90 days. Physicians, 6 months or 5 refills. They may be called into the pharmacy, and a special controlled substance prescription is not needed. So unlike the Schedule 2s, the Schedule 3 through 5s, you don't need to go through all of that additional work. Okay, they can be written on a regular prescription pad, so you can just write them off like you would for your regular prescriptions that you're giving out to your patients. All right, now dangerous drugs. What do we mean when we say dangerous drugs? Because certainly we would classify something like heroin to be a dangerous drug, but we already know that that's in a Schedule 1 for the DEA. So this term, when we say dangerous drugs, okay, dangerous drugs are going to be considered drugs that don't fall into the controlled substance category. All right, but they are not over-the-counter medications. So we're not necessarily talking about something like Excedrin for headaches, which you could easily buy over the counter, but they're not going to fall into the controlled substance category. In other words, the DEA is not going to be as interested in drugs like this. So they require a prescription because they're not over the counter. And, the example given here for the hydrochlorothiazide, that's a blood pressure pill. It requires a prescription, but it's not a controlled substance, right? So it's not like the DEA needs to be notified if this is being prescribed, that it's going out onto the street. However, this is something that should be regulated at least to the point that the physician knows it needs to be through prescription and should be monitored through the physician-patient relationship. Another synonym for dangerous drug is legend drug. Okay, dangerous drugs contain a legend which states, caution, federal law prohibits dispensing without a prescription. Also remember that an overdose with dangerous drugs does not need to be reported, but penalty group 1 drug overdoses must be reported. So that's an important difference, and many times this will appear as an exam question. All right, pharmacist. So unless it states dispense as written or DAW, a pharmacist may automatically substitute a brand name medication for a generic medication if the cost of the generic is lower than the brand name and the patient does not refuse the substitution. Okay, so notice that that's underlined, that's important. Okay, so if it doesn't say dispense as written, meaning that in that case, the pharmacist needs to give the exact brand name of that medication. Okay, they can substitute in something cheaper that is lower in price, but the patient is going to have to accept that. If they refuse it, then you have to do the one that was written. So dispensing medication from a physician's office instead of a pharmacy. Physicians in general are not allowed to be dispensing medications to patients unless they practice in a rural area, okay? So if there are less than 5,000 in a county, or if there are less than 2,500 in a town, and the closest pharmacy is greater than 15 miles away. All right, so if that is the case, let's say you're way out in rural Montana, right? We're really looking at Texas in this case, but I'm just trying to give an example. So in a case like this, where let's say the closest pharmacy is 30 miles out, and you're in a town of 500 or something like that, you're the only physician in the town. At that point, you could look at dispensing medication from your office. You must comply with labeling, packaging, and record keeping, and you must notify the board of pharmacy and medical examiner. So people need to be aware. You have to contact the boards and let them know that this is something that's going on. And obviously, you need to meet those requirements. If you are at a major or metropolitan area, it's not going to be okay for you to be dispensing out of your office when there's a CVS across the street. All right. Prescribing to friends and family. So when you're looking at prescribing to friends and family members without a documented history or physical exam, it can be grounds for disciplinary action. So in other words, we're not going to have any drug nepotism, so to speak, where you're sort of hooking people up. Okay? Additionally, prescribing controlled substances in the absence of an immediate need, where an immediate need is considered no more than 72 hours, can also be grounds for disciplinary action. So in other words, if you're going to be treating a family member, they need to be coming in and doing their documented history and physical exams. You are not calling in prescriptions for them and calling in favors left and right, without their proper upkeep. Okay, so starting to wrap this section up here, we're going to just briefly talk about DMSO and light trial. So a licensed physician may not prescribe or administer DMSO in a formulation if not approved for human use by the FDA, unless the physician, and here are the exceptions here, okay, so unless the physician is to provide a written statement to the patient informing the patient that DMSO in the formulation to be prescribed or administered has not been approved by the FDA, Okay, or inform the patient of alternative methods of treatment for the patient's disorder and the potential for alternative methods for cure. So, in other words, the patient needs to be aware that you would be doing this, and they have to give you the okay anyway. And you can see you have to make this statement here about it not being proved by the FDA or that there are alternatives. All right, now, Lighttriol, also known as amygdalin, is a chemical found in plants, most notably in apricot seeds and bitter almonds. There was initial hope that Lighttriol would be effective for cancer treatment, but it was subsequently found to be ineffective and toxic. So the FDA prohibited interstate shipment in 1977, and subsequently many states, and this includes Texas, okay, legalized the use of Lighttriol in order to protect patient access. So according to Texas law, a licensed physician may prescribe or administer it in the treatment of cancer. And then finally, we are going to discuss intractable pain. So intractable pain is defined as pain that cannot be removed or otherwise treated in a generally accepted course of medical practice. So relief and cure of the cause of the pain is not possible and has not been found after reasonable efforts. So you have to make reasonable efforts to attempt to cure or eliminate this pain before it would be classified this way. All right, now, there is an Intractable Pain Act of 2003 that protects physicians from prescribing controlled substances or dangerous drugs to patients with this type of pain. However, a physician who prescribes for a non-legitimate purpose, or if the physician knows that the patient is using it for non-therapeutic purposes, they may face license suspension or the license may be revoked completely. Okay, so just an important note in regards to that. So that is it for the content in relation to this preparatory course. So first and foremost, thank you all very much for taking the time to learn with us and trusting us to be your source in preparing for the jurisprudence exam here in Texas. A couple of tips. Be sure to re-watch any of this content if you feel like you might have questions or you need to review some of the material again. Be sure to practice the simulation test. So this course comes with simulation questions that will help you prepare for taking the actual exam. Those will be of great benefit to you, and they should match the material that we've been discussing here. And you will do great if you've gone through this course and you've done all of the practice questions. So thank you again, and good luck to everybody.